The court is now in session. Will Judge J. Cedrickson presiding.
You may be seated. And, oh, there you are. 2 days in a row. Mr. Ganatra.
Always a pleasure, Your Honor. Nimish Ganatra, Senior Assistant Prosecuting Attorney on behalf of the people. At this time, the people move to waive any conflict between this honorable court and the Office of Public Defender. Prosecutor's Office does not believe a conflict exists, but if there's one present, we waive that all. Public Defender's Office for this honorable court. Thank you.
Thank you. And I presume Mr. Overwater.
Yes, Your Honor. Kenneth Overwater, Assistant Public Defender. Your Honor, the public defender also does not believe that any conflict exists, but to the extent that it would, or that anyone may claim that it would, we would waive any such conflict.
All right. The court, for its part, also does not believe there's a conflict either, and Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case, People's State of Michigan versus Deja Hogan.
Hello.
Hello.
On behalf of the people.
Assistant Public Defender Jay Bellinger on behalf of Deja Hogan, Your Honor. Can you
Ms.
please state?
Hogan, can you state your name, please?
Deja Hogan.
Thank you.
Thank you. Your Honor, I have not had an opportunity to meet with Deja Hogan at this time. I'm just asking if there's 3 weeks in order to go to Huron Valley and do so. I have another client to meet there as well, so.
That objection, probable cause is adjourned August 8th, 2024, 9 a.m. Bond continued.
Thank you.
Thank you. Thank you, Ms. Hogan. Court does call the case of the people versus Mark Kimlin.
On behalf of the people.
Your Honor, Alexis Plumey appearing on behalf of Mr. Kimlin, who is by Zoom. Mr. Kimlin, could you just state your full name?
This is Mark Killen. Good afternoon. Well, good morning, Your Honor.
Morning.
And Your Honor, at this time, I have not had a chance to make it out to Jackson County to meet with Mr. Kimlin. I was just approved for remote visits, so I should be doing that tomorrow. But if we could do a 2-week adjournment so that I have time to speak with him and go over the case, that would be ideal.
That objection, August 1st, 2024, 9 a.m.
Can I speak real quick, sir?
Pardon?
Can I speak real quick, sir? I'm at Channer Road right now, and I'm trying to get to rehab like I told you.
Right. And are you on hold because of this case?
Yes, I am. I've got my lawyer, what do you call it? My probation officer here tried to get me out a month and a half ago to go to Jonesville, to Hope House, or Dawn Farms in Ypsilanti, Ann Arbor.
So do they have, I mean, are you approved to go at this point?
Yes, sir. Just had to hold through you guys.
Got it. Okay, so counsel, you're meeting with him tomorrow?
Yes.
All right, so here's what we're gonna do, and you're right, I recall you saying this to me. After you meet with him, then, and discuss that with him and everything, then I think I need a written order just sent to the court for my signature so that that can happen.
I will do that, Your Honor.
For what it's worth, I don't have an objection from being released to treatment.
Yeah,
So I'll review that order and son.
okay, very good. You got that? That'll work for you, Mr. Kimlin?
Yeah, thank you, sir, so much.
Thank you.
Thank
Good
you.
luck.
Thank you.
Court does call the case of the people versus Kirk Prescott.
On behalf of Mr. Kirk Prescott. Mr. Prescott, I understand he's.
Prescott.
Hello, sir. State your name.
Kirk Prescott.
Thank you.
Judge, I was just appointed this case yesterday, and it's my understanding he's in Pennsylvania.
I'm not sure. Are you in Pennsylvania, sir?
Yes, I'm currently in Waymark, Pennsylvania.
Did you catch that, Judge? He's currently what?
What was that last thing you said, sir?
Yes, I am. I'm in Pennsylvania.
All right. Thank you.
Judge, can I get maybe a 3-week adjournment, see if I can make arrangements to meet with him?
All right. You need 4 weeks.
Yeah, for the Bureau of Prisons.
All right. Since it's Bureau of Prisons, we need it's gonna have to be
Fine.
a 4-week adjournment. So that's 3. All right. I'll adjourn the matter without objection to August 15th, 2024, 9 a.m.
Mr. Prescott, my name is Bob Kilowald. I'm going to try and make a hearing conference with you, okay?
Yeah, you said you trying to schedule a hearing conference with me?
Yes, I'm going to schedule a hearing. All right, thank you.
All right. Thank you, Mr. Prescott.
What you say your name was? Is it a way I could contact you?
His name is Bob Kilowald. Everybody knows him.
Bob
I don't
Kilowald.
know about that. I will try and contact you this week.
All right, thank you.
Thanks, Judge.
All right. Thank you.
All right.
Court does call the cases of the people versus Jason Allen.
Your Honor, I'm on several of the cases. I'm on case 24F10693 and 24F20704.
Assistant Public Defender Constable based on behalf of Jason Allen, matters ending in 1826, 0692, 0695.
I've got 60693 and
0694.
the balance of the cases.
Your Honor, at this time, my client is prepared to waive his preliminary exam on all these matters and seek an offer at circuit court. We do have the waiver.
And on yours?
Waive your right to have an exam and go up to circuit court.
Yes.
Okay.
And all of the
Judge. Sure.
Sir, is all of that correct?
Yes, Your Honor.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed it.
Yes, Your Honor.
You understand you'll not have that hearing on any of these matters and that you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right on these matters. Preliminary examination having been waived, defendant is bound over to circuit court on all felonies with misdemeanors following. I'll do it that way.
Thank you, Your Honor.
Your
This time
Honor,
we waive formal readings and stand mute to the charge.
I would also waive the reading of the information, stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to all counts. Pretrial in these matters will be set for
July 25th at 1:30 before Judge Slade Thursday.
July 25th, 2024, 1:30, Slade Thursday.
Judge Slade Thursday. I'm gonna come and see you before.
Okay.
Thanks, bro. Okay, take care. Thank you.
Bond on these matters will continue. Thank you. And yeah, those will, and then they need the information. So you need to get to the prosecutors to just do this part. Keep the felony straight. Court calls the case of the people versus Samantha Collins.
Good morning, Your Honor. Alexis Plumai appearing on behalf of Samantha Collins.
And good morning, Your Honor. Hassan Hamadi on behalf also Samantha Collins. Your Honor, our office was retained a few days ago, filed an appearance, but I did substitution of counsel, which I will do soon after I leave court.
All right.
So at this time, we're just going to be asking for a continuance of the probable cause conference to get discovery from the people.
An adjournment.
Please.
How much time did you need?
Few weeks, Your Honor.
August 8th, without objection, 2024, 9 a.m. Or as your invite indicates, bond will.
Thank you, Your Honor.
Thank you. Court calls the cases of the people versus Regina Brown.
Kenneth
Overwater, Assistant Public Defender, on behalf of Ms. Brown, who stands to my right. Ms. Brown, would you state your name for the record, please?
Regina Brown.
Your Honor, I'd ask to adjourn the probable cause conference. I'll be submitting felony drug court applications on these matters.
On all of these matters.
Yes, sir.
Any objection?
No, Your Honor.
How much time did you need to do that?
I would ask for 3 weeks.
Probable cause conference, August 8th, 2024, 9 a.m. Bond continued.
Thank you.
Court calls case People versus Mario Atkins. Good morning.
Morning, Your Honor. Sam Bernstein with my behalf of Mr. Atkins.
Bill Atkins, you get your hands out of your pockets. All right.
Your Honor, we're just asking for the briefest of adjournments and speaking about things while I'm bringing, then we'll move the case forward.
Probable cause conference, August 1st, 2024, 9 a.m. without objection. Bond continued.
Thank you, Your Honor.
Court calls case People versus Control Cooper.
Sinatra for the people.
Your Honor, Peyton DeWitt, student attorney, requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Hannah Apple.
Oh, really? Seriously? Okay, cool. Permission to practice is granted.
Thank you, Your Honor. Please state your name for the record.
Control Cooper. Thank you.
Your Honor, at this time, we waive my client's right to a preliminary exam.
Is that correct, sir? And you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. Yeah. And you understand that that means that you'll not have that hearing, that you'll proceed to circuit court for further resolution. Yeah. People also waive their right.
That's right.
Preliminary examination having been waived. Sir, turn around.
You ain't got to talk to me like that. I'm gonna turn around though.
Turn around, please.
Thank you.
And then having waived formal reading, standing mute, court will enter a not guilty plea. Is that correct, counsel?
Yes, it is.
Pretrial will be set for
July 25th at 1:30 before Judge Slate Thursday.
July 25th, 2024, 1:30 Slate Thursday. Bond continued.
Thank you, Your Honor.
Yes. Should be in the file. Court calls the case People versus Andrew O'Connor.
Sam Bernstein for Mr. Ancana, Your Honor, is approaching the podium. State your name for the court.
Andrew Ancona.
Oh, thank you.
Your Honor, we're asking the court to please set this for preliminary examination. All discovery is complete at this time.
People would have their witnesses available the 30th. Well, hold on a second.
At the appropriate time, I would also like to address the matter.
Pardon?
At the appropriate time, I'd also like to address bond if we are looking at, especially if we are looking at additional dates, just to make that clear.
All right. What is to, bless you, as to the issue, bond?
Thank you, Your Honor. I am requesting that Your Honor increase bond to 200,000 cash surety. At the time that my office charged this case, we requested 200,000 cash surety. This is an armed robbery case. While the defendant is young, he does have a juvenile. This case is about the defendant being essentially the driver of a vehicle and then the getaway driver after an armed robbery. He is the person that the victim knows and is connected to. He's the person that the victim has a history with, and he's the person that knows information about the victim that causes the victim to believe that it is this defendant that kind of set up and orchestrated this armed robbery. Essentially, the defendant is driving a vehicle. He has his friend who ultimately becomes the armed robbery victim in the vehicle with him, and there are two other people in the vehicle with them. They're driving around. At some point, says, "Please drive me back to this particular address." They drive him back to that address, and when the victim gets out of the car to leave, the two other people in the vehicle get out of the car with him. One of those two people produces a handgun and actually puts it into the victim's chest and orders the victim to empty his pockets and turn over. Typically, the victim carries cash on him, which is something that he knows that this defendant knows about him. This is who they left his cash in his vehicle, so all he has is his cell phone. Like the cell phone over to the people that robbed him. He then called the police. The two people that robbed him got into this defendant's car, and this defendant then drove them away. Later, this defendant was arrested, and when the police were initially talking to him, he was giving the police information about who was in the vehicle, where they were. There was a point where a woman who was nearby where this interview was taking place was screaming at him to request a lawyer, and that was the point where he stopped providing any additional information. Given the danger that he presents to the community, the fact that he has a history with weapons and is now involved in this armed robbery, I'm renewing my office's request for 200,000 cash surety on this file. Thank you, Your Honor.
Your Honor, Mr. Ancona has actually been on a home confinement tether for the last month. So he has been at home, if not left that home without permission for that entire time. He has abided by the exact conditions of what he's supposed to do on that home confinement tether, Your Honor. I want to point out a couple of things about what he's been doing since then, because I think the ultimate question, is whether he can be in the community safely. He has been in school for this entire time. He attends online school. He has put his kind of foot on the gas for schoolwork, so to speak. I got a letter from his advisor at WAVE. She writes that I've worked with Andrew Ancona on my advisory team at Washtenaw Alliance for virtual education for the past 2 years. Andrew is fully capable of making great academic progress when he is motivated and puts his mind to it. He is respectful and appropriate with adults in our space. This month, Andrew has submitted several assignments in U.S. history, English, and civics, and attended live online classes. He and I had a detailed meeting about his academic progress and specific modules and assignments to work on in the days and weeks ahead to continue to make progress. It is my hope that he can continue to be engaged with the work here at WAVE, and he has a large support network here ready and willing to help him. So he's been doing a lot of engagement with school, Your Honor. He has also signed up working with a counselor at Solars and Associates. The counselor wrote me a letter saying that Andrew Ancona has begun seeing me for therapy services on July 2nd. During his initial intake session, he disclosed the reasons he was seeking counseling, namely addressing the issues that brought him into contact with the justice system. He has shown an active engagement during his therapy sessions. So he is trying to actively work on the reasons that brought him here, Your Honor. Lastly, he's reached out to First Step Referral Services and got into some programming that is signed up for later this month. So I think when it comes to the question of whether he can be out safely, he is showing that he can be. The reality is, if he leaves that house without permission, that tether will start alerting and law enforcement will be there faster than he can count to 3. He literally cannot go anywhere outside that home and do anything that we're worried about. He is stuck at home. He has been at home. He is being constructive at home. He's being proactive in mitigation efforts at home, Your Honor. And so when it comes to the question of whether he can be out safely, he is showing every day that he can do that, Your Honor. And he would respectfully ask the chance to continue doing that on bond.
Anything additional from the people?
Nothing further, Your Honor. Thank you.
Court, in reviewing the file in this case, I am unclear as to how this defendant got a personal recognizance bond in the first place. I don't looking at everything, listening to the allegations in the case, court believes that that in and of itself was an abuse of discretion and inappropriate, taking into account what the defendant has done, as elicited by counsel. The court will modify the defendant's bond. Defendant's bond is hereby set in the amount of 50,000, but that'd be a cash or surety bond. So defendant is remanded.
Sorry, I'll talk to you. Okay.
I will set preliminary examination in this matter. Did you want the 23rd or 30th?
The 23rd is fine, Your Honor. That's, yeah, the
People
23rd.
have their witnesses available the 23rd.
At least, Your Honor.
All right. Preliminary examination, July 23rd,
Thank you, Your Honor.
before Judge Washington. Thank you.
Thank you, Your Honor.
Thank you. Court calls case People versus Keelan Evans.
Kind of overload.
Sorry, you go first.
No, please.
Nicole Hughes on behalf of people.
Kenneth Overwater, Assistant Public Defender on behalf of Mr. Evans. Your Honor, we have set this matter for preliminary examination,
Discovery is complete.
to my knowledge.
People have their witnesses available on the 30th.
At least, Your Honor.
Preliminary examination in person, July 30th, 2024, 9 a.m. That is before Judge Freshour. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case People versus Tariq Lee, 2 cases. Tariq Lee?
Hello?
Yes. Hang on, I'm waiting for counsel.
Good morning, Your Honor. Sam Bernstein with on behalf of Mr. Lee. He's here by Zoom.
Lee, state your name, please.
Tariq Lee?
You're not going to be waiving the preliminary examination in both cases.
Is that correct, Mr. Lee?
Yes, Your Honor.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1 through 3 with 4 and 5 following. That's on case 260, and bound over to circuit court on both counts in the other matter.
We ask the court to please waive reading. Ask the court to please continue not guilty plea and for a circuit court pretrial date.
And in every way, formal reading, standing mute, court will enter a not guilty plea as to all counts. Pretrial in this matter will be set for
August 27th at 1:30 before Judge County.
August 27, 2024, 1:30.
Thank you, Your Honor.
Thank you. Bond continued.
May I send this information?
Yes, ma'am. So there's. Court does call the case of the People versus Daniel Greenwood.
Your Honor, good morning. This is Matthew Mansour, Assistant Public Defender, with and on behalf of Mr. Greenwood, who appears to my right. Mr. Greenwood, can you state your name for the record, please?
Daniel Lowell Greenwood.
Good morning.
Your Honor, we're waiting on, I believe, just one 911 call that should be in today. We were going to set this for an exam. Other than that, discovery is complete.
That is correct, Your Honor. The 911 call has been requested already this week. Mr. Holtman has been very quick with turning those over. So as soon as I get that, I will share that with the defense.
All other discoveries complete.
That is correct.
Yes, Your Honor.
No adjournment will be given if that call is not here. You understand that, counsel?
Understood, Your Honor.
People have their witnesses available the 30th.
We will do our best.
Preliminary examination in person, July 30th, 2024, 9 a.m. That is before. Exactly. Before me. Bond, it's before me, bond continue.
Thanks, Your Honor. Thank you.
Just another attorney. Court calls the case, People versus Alexander Filippini. Probably said that all wrong.
Sam Bernstein with and on behalf of Mr. Filippi. Say your name, please.
Alexander Philippi.
Your Honor, we're going to be waiving the preliminary examination. I had a form filled out.
All right, we can get that. Sir, is that correct?
Yes.
You understand the preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
We do, Your
Preliminary examination having been waived, defendant bound over to circuit court on a single count. Mr. Bernstein.
Your Honor, please waive reading. Mr. Filippi stands mute and we're ready for a pretrial date.
Defendant having waived formal reading, standing mute, court not guilty plea. Pretrial will be set for
August 27th at 1:30 for Dutchess County.
August 27, 2004, 1:30.
Thank you.
All right, cool. Thanks. Yes, we're good. Over to you. Bond continue. Give that to her. Court calls case People versus Kenneth Hall.
Thank you, Your Honor. This is Matthew Mansour, Assistant Public Defender, with and on behalf of Mr. Hall, who appears to my right.
Kenneth Hall.
And he's waiving his right to preliminary examination.
That is correct, Your Honor.
Mr. Hall, you understand that that's what you're doing?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes.
You understand that?
Yes.
Okay. And you understand you'll not have that hearing, proceed to circuit court for further resolution?
Correct.
All right, thank you. People also waive their right.
Yes, Your Honor. Thank you.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1 and 2 with 3 and 4 following.
Thank you, Your Honor. We will wait for more reading and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to all 4 counts. Pretrial in this matter will be set for
July 31st at 1:30 before Judge Conlon.
July 31st, 2024, 1:30, Judge Conlon. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case People versus Erica Brown.
Working for on behalf of the people.
Good morning, Your Honor. Christina Costantino, appearing on behalf of Erica Brown. Ms. Brown, can you unmute and state your name for the record?
Erica Brown.
All right, thank you. All right, what are we doing?
Your Honor, the date and time set for PCC. We are asking to have this matter set for a preliminary examination. Discovery is complete.
Yes.
I just was shared. Where's that today? I just shared the media notice with them yesterday, and I just requested the 911 call yesterday. I just noticed that we had not received it yet, so I'm not sure if Ms. Costantino has received videos in this file yet. I just shared them late yesterday afternoon, but I know she does not have the 911.
And Judge, I did receive several videos, so I believe I have all of the videos in this case. I understand the 911 call has not been provided. We would still ask to have the court set for exam with the understanding that there won't be any adjournments if the 911 call is not provided prior to.
People have their witnesses available on the 30th. Preliminary examination in person will be set July 30th, 2024, 9 a.m. before Judge Fresh Hour. Bond will continue. Thank you.
And Judge, would the court be
Yes.
willing to consider removal of Ms. Brown's tether? I can provide some additional information if the court's willing to hear some argument.
What would be the basis for?
Your Honor, she is employed, and part of her employment, she typically does wear shorts. Given the hot weather conditions that this summer has brought, of course, the tether is noticeable and visible, and it has caused her a bit of an issue with her employment, where she has had to wear pants instead of work. She's 37 years old.
Want me to
She
remove the
doesn't
tether
have
because
any
of climate change?
history. Yes, Judge.
Any response from the people?
This is a DB case, Your Honor. I don't think it's appropriate to remove their without giving them medical reason to do so, at least not before the preliminary exam.
I think it can be raised at the preliminary examination after the testimony's in, and in looking through the file, I think that the tether is appropriate. And I understand it may cause some inconvenience, but so would incarceration. So I'm going to deny the request for the removal of the tether.
Understood, Judge.
Thank
Thank
you.
you. Have a good rest of your day.
You do the same. Court calls the case People versus Miguel Harper.
Good morning, Your Honor. Marcia Creech on behalf of Mr. Harper. Mr. Harper, can you please state your name?
Miguel Harper.
Thank you. Okay, what are we doing?
Your Honor, Mr. Harper has a PCC scheduled for July 25th in another matter. I'd be requesting this PCC be adjourned to that, so both cases can track
So he's
together.
got one next week.
I'm sorry?
He has one next week.
Yes, Your Honor, a different matter.
Without objection, probable cause July 25th, 2024, 9 a.m.
Thank you. Thank you, sir.
Thank you. Interesting. Court calls the case People versus Gregory Case. Cayce.
Andrew Childers appearing on behalf of the people.
And good morning, Your Honor. Sydney Rushing appearing on behalf of Mr. Casey, appearing today. Mr. Casey, can you please state your name for the record?
It's Gregory Clem Casey.
Okay.
Thank you.
What are we doing?
Your Honor, today is the date and time set for a probable cause conference. I was just recently appointed, so I have not yet received discovery. So this time, Your Honor, we're requesting an adjournment to another PCC date, please.
Objection. Probable cause conference will be adjourned to August 8th, 2024, 9 a.m. Bond continued.
Thank you, Your Honor. And
Thank you so much.
Rushing, if you could give me a call. when
Yep, I
you're done
will.
with it. Thank you.
All right, you're all set.
Thank you, Your Honor.
Thank you. Court calls the case People versus Rosemary Harrell.
Assistant Public Defender Jay Bellin on behalf of Ms. Harrell. Name for the record?
Rosemary Harrell.
Okay. I have a plea form. Is that what we're doing today?
I'm sorry, Your Honor. Yes, it's my understanding that there's going to be a plea today. We have provided that to the court.
Has she signed a advice to rights form?
No, Your Honor. I'm so sorry.
Get off your phone and have her sign a form. Please.
Will do. Thank you. You're okay. Right here.
Well, they're doing that. The court's understanding of the agreement is that the defendant will be pleading guilty to an added count for of arson. Is that the 5th degree? In the 5th degree. That is a misdemeanor punishable by up to 1 year incarceration and or a $2,000 fine plus court cost. Fine could be increased if the value of the property that's greater than 2,000 that would become the maximum fine. And upon the defendant's plea to that charge, counts 1, 2, and 3 would be dismissed. And that the defendant to go to mental health court. That is the court's full understanding of the agreement. Is that correct?
That's correct, Your Honor. Thank you.
And that is our understanding, Your Honor.
All right. May I have a sworn? Please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
Yes.
State your name again for the record.
Rosemary Harrell.
All right. Ms. Harrell, it is this court's understanding that you are going to be pleading guilty to the charge of arson in the 5th degree. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. Fine could be increased to 3 times the value of the property taken or destroyed or otherwise injured. If that's greater than $2,000, that would become the maximum fine. You understand?
Yes.
You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge in this matter, and you would be sentenced before Judge Washington in the 14B District Court.
Yes.
Understanding all of that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form today, is that correct?
Yes.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights if you're part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
That's correct. Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
No.
Anybody threaten you or coerce?
No.
You're doing this voluntarily
Yes, Your Honor.
of your own free will? And because you believe that you're indeed guilty of this offense?
Yes.
February 23rd, 2024, at the location of 2010 Whitaker Road in Ypsilanti Township, Washington County, State of Michigan. What did you do that makes you think that you're guilty of this offense?
Okay. I attempted to start a fire and I ran in there with a machete.
Okay.
Oh, with
This is at a croak, right?
Yes.
Okay. What'd you do that makes you think that you're guilty of the charge of arson?
I'm gonna start a fire now.
Okay, you tried to start a fire where?
At the Kroger. I tried to start a fire at the Kroger. In the liquor section.
Okay, that's what I'm trying to get to. You went in the store. You went to the liquor section. Is that correct?
Yes.
And then you attempted to try to start a fire there.
Yes.
Okay. And were you successful in that?
No.
But you attempted to do that and burn property.
Yes.
And that property didn't belong to you.
Right.
I think I've got everything. Counsel, have I complied with the court?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 4. Counts 1, 2, and 3 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
August 22nd, 10 a.m. before Judge Washington.
August 22nd, 2024, 10 a.m. before Judge Washington.
Thank you, Your Honor. And if we may, with regard to bond.
Yes.
Your Honor, my client advises that they can stay in Ypsilanti with their mother, willing to do home confinement, willing to do GPS tether, asking for release in light of the fact that they have been accepted in the mental health treatment court. So just asking for.
But is she currently receiving treatment at this point?
Not at this point, Your Honor, as far as I know, just the acceptance into the mental health treatment court at this time.
All right. I don't need a response. I'm going to deny the motion for bond reduction at this time.
Thank you.
You can take that up with Judge Washington. Thank you. Court calls the case of the people versus Shala. Is it Gildan?
Jessica Blanche.
Good morning, Judge Rebecca TFLP 62311 on behalf of Shala Gildan. Your Honor, unfortunately, I've been unsuccessful in reaching my client. I have no knowledge of her whereabouts.
All right. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately.
Thank you, Judge.
Thank you. Court calls case people versus Keelan Harris.
Morning, Your Honor. Sam Bernstein with and on behalf of Mr. Harris.
Keelan Harris.
Thank you.
We're asking the court to please set this for a preliminary examination, Your Honor. Discovery is complete.
People, other witnesses available on the 30th.
I will try my best, Your Honor.
Preliminary examination in person will be set July 30th, 2024, 9 a.m. before me. And we'll continue. Thank you.
Your Honor.
Court calls the case of the people versus Malik Summers.
Judge, we believe there may be some discovery to be obtained from the party store video. So I had spoken with Ms. Hughes. And so we're asking for an adjournment of the PCC.
All right, how much time would you need to check that out and try to see?
We could go ahead at least 3 weeks, please.
All right. Probable cause conference will be adjourned August 8th, 2024, 9 a.m. Bond continue.
Thanks, Judge.
Thank you.
Have a nice day.
Court calls the case of the people versus James Johnson.
Assistant prosecuting attorney working with on behalf of people.
Sam Bernstein for Mr. Johnson, Your Honor. Here.
Yeah.
What's going on, man?
Not much. You look good in orange.
No.
All right.
Oh, yeah. So we're asking the court to please set this for a preliminary exam, Your Honor.
Your Honor, we
Yeah.
have all discovery shared with the exception of the 911 call that was requested earlier this week. It should be over to Mr. Bernstein by the latest on Monday. My expectation would be more likely that it gets to him tomorrow. Then the court, well, I would like to address Bond.
Why don't you go ahead and address Bond?
So I understand in this case, bond is currently set at 10,000, cash or surety with no 10% privilege. We did request 150,000 on this case originally. I understand he has his bond currently denied out of the circuit court, and multiple holds in this case. I am actually requesting that bond be raised today, as well as his phone privileges be revoked. I am concerned because the way that I see this playing out is that he was taken into custody for this event that occurred back on May 2nd. After he was taken into custody, he was in custody for a period of time, then was released. Before he was released, we had stipulated to adjourn this case to May 23rd. On that day, he failed to appear and a bench warrant was issued. He was then picked up and arraigned on the bench warrant on July 9th and given the 10,000 cash or surety without 10% privilege. In the time that he was in custody before he was released and since he has been picked up, he has called the victim 105 times at her personal number, as well as called the family line 110 times, where the victim answers that phone among other people a number of times. I don't know what contacts he had with the victim while he was out of custody, but given his failure to appear previously, as well as the extensive violations in the form of calling the victim, I would be asking for the increase in his phone privilege to be revoked today.
Your Honor, as far as the phone calls go, Mr. Johnson states adamantly that he's not called Miss Vesey. He says that it was another woman that he's been calling. And that he has not had any contact with Miss Vesey since he's been in jail by phone, Your Honor.
I apologize. It is the victim's phone number because the victim has called our office and provided that phone number that he has called 105 times as her point of contact to our office.
That's my phone. That's not her number. I call my other girlfriend. That's my.
He says he's calling his other girlfriend, Your Honor. I'm sure Miss Barossa will get me the phone calls. I'll listen to him ASAP. If there's something different, then I'll know within like a day or two. I know what Miss Vesey sounds like on the phone, so I'll be able to tell whether it's her or not.
Your Honor, yeah, I'll say something, Your Honor. Usually doesn't work well, but go ahead. I know. Yeah, the number that I've been calling, I got two girlfriends. One is Mrs. Vesey and the other is Jaleesa. I called Jaleesa off of my phone number. It's an 858 number. It's registered to my name. It's in my name. Miss Vesey's phone number, I do not call at all. And when I was coming out here, I seen Miss Vesey in the back. Miss Vesey can attest to you. I ain't called her or I haven't called her. I know the contact order, so I know I ain't supposed to have no contact with Mrs. Vesey at all. So I called my other girlfriend, which is Jaleesa. And once you hear the phone, once you get the phone records, the 100 and whatever times, I'm not too for sure how many times I called her, but once you get the phone records and you hear the phone records, you'll clearly hear that it's not Mrs. Vesey, it's Miss Jaleesa that I am talking to on the phone. Now, if you can hear the records as well, you hear me on that phone call, those same phone calls, telling Jaleesa that I cannot have no contact with Mrs. Vesey. And for her, I can't have no third party contact as well with Mrs. Vesey. So once y'all able to get the contact or the phone records or whatever to my attorney in this court, y'all can listen to them and make the determination. But I don't call Mrs. Vesey, and Mrs. Vesey is in the. All right. Well, let me ask you this then, since you decided to volunteer this. As between your two girlfriends, would there be any reason they would share a number? No, there's no reason that they would share. No. So why would the prosecutor indicate that the number that the victim in this case gives them to contact her is the same number that you're calling from the jail? Now that I don't know. I don't know why she would indicate that or what even would give the indications that I'm talking to Mrs. Vesey, but Mrs. Vesey is right there. Okay, do these two women know each other? Yeah, they know each other for sure. I mean, like I said, we was in a three-way relationship, so like they know each other for sure. Okay. And Mrs. Vesey right there, if you would like to call her up here. No. Or she can attest. I can't talk to her. I got both of them pregnant at the same. You know what I'm saying? So like,
to be fair to James, Your Honor, what we're not hearing is anything about the substance of those calls, whether he's talking about court or proceedings or anything directly related to Miss Vesey.
the same time? Yeah. Okay. All right.
Yeah.
Go ahead. No. My bad. Yeah. Sorry, Mr. Bernstein. I didn't mean to interrupt.
I was just saying, Judge, what we're not hearing is the substance of those calls that relate specifically to Miss Vesey. Anything that would indicate that it is Miss Vesey herself. We're talking about the number, but as far as like what's on those calls, I mean, what we're not hearing does kind of support what James is saying, that he wasn't calling Miss Vesey, Your Honor.
Okay, so there's no way without me seeing, I mean, you haven't seen them, Mr. Bernstein, that we're gonna know. But my posture on those cases is that if the people are representing to me that the number is the same, I don't know what's going on. Doesn't matter to me. All I know is that the number is the same. I'm not sure what those conversations are. Mr. Bernstein will listen to it, but this time I'm going to revoke your phone privileges. And certainly, Mr. Bernstein, after you hear the calls, if the court needs to reconsider that, I will entertain that and potentially restore his phone privileges. Okay. So that means is when you revoke my phone privilege, is it to that number or is it to all my family? I'm sorry? Because I call my grandmother, my other kids, mothers, and all that. So is it revoking that number? I get you. I'm just saying that what I'm hearing right now is that you violated a condition of your bond. You're telling me you haven't. I've got this phone number. Your counsel hasn't heard it. So what I'm saying is I am, as an initial position, going to revoke your phone privileges. He'll get the phone messages. He'll be able to get to you they can get to me. I'm not saying I might not restore them, but at this point, this is what I'm gonna do.
Okay.
Okay?
All right. I'll get on it fast.
See, because I need to. So his phone privileges at this time are revoked. With reference to the bond amount, when is the other hearing on?
It should,
So, and that's the case that bond's been denied.
yes,
So, okay,
He's not going anywhere anyway,
well,
so.
I know. I get that. That was gonna be my point. I just wanted to check the dates. And so I'm just gonna continue his bond as it's currently sat until we can get to the bottom of, because he's gonna have a preliminary examination before that other case comes up. I'll set preliminary examination in person, July 30th, 2024, 9 a.m. That's before me. Thank you.
Thank you, Your Honor.
Same time. Court calls case people state of Michigan versus Bobby. Mr. Johnson, keep going. Just keep moving. Quit talking. Court calls case people state of Michigan versus Bobby Beach the second.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Beach, who is present via Zoom. Mr. Beach, can you please unmute and state your name for the record?
You don't have it?
I have other devices.
Your Honor, I believe that is him in the white t-shirt with the headphones on.
Okay. Mr. Beach? If that's you, wave your hand. I don't know who he's talking to.
Mr. Beach, can you please unmute and state your name for the record?
Bobby Beach, BOBBY.
Okay, that's it.
Thank you, Your Honor. We are respectfully requesting an adjournment so I can have a meaningful conversation with my client.
Probable cause conference, August 1st, 2024, 9 a.m. Bond continued.
Thank you, Your Honor. Thank you, Mr. Beach. You can log off now.
Court calls the case People versus James Kimbrough.
Jessica Blanchard, on behalf of.
Kimbrough? Hold on. I got in touch. You're not there?
It's come. Edward Lucas on behalf of James Kimbrell and the matter ending in 950.
No, you got to be at this side, fella.
Other way, Peter. Other way.
Other way. No, you two switch. He just started. All right. Go ahead. Go.
Your Honor, at this time, we're requesting an adjournment for further negotiations.
Did you put your appearance? Oh, I didn't think you did.
Peyton DeWitt on behalf of Mr. Kimball.
And Edward Lucas on behalf of James Kimbrell and the matter ending in 950.
All right. What are we doing?
The matter in 950, I'm looking for some videos. I had spoken to the prosecutor's office. I would have that week. I'd ask for a week or two adjournment.
And what are we doing in your case?
We're adjourning for further negotiation. About the same amount of time would be appropriate.
Probable cause conference. That objection, August 8th, 2024, 9 a.m. Bond will continue on all these matters. All right, thank you.
Thank you, Your Honor.
Court calls case People versus Tristan Bell.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Bell. Unfortunately, I have not had contact with. Your Honor, I would note that there was some communication between him and Community Corrections yesterday. I received an email. There was a bond violation for not failing to report.
Yes.
There was some indication that he resides about an hour away. I would ask for an adjournment.
I do see the violation report. Bench warrant will issue for defendant's failure to appear. Bond $25,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Court calls case People versus Jeremiah Laster.
And Assistant Public Defender Lamisa filling in for Mr. Bellinger. I'm told this case is going to be set for exam, understanding that there will be no adjournment if they do not have all discovery, but I believe he should have the remainder tomorrow.
Your name, sir?
Jeremiah Laster.
Thank you.
Everything's been shared except for the 911 call that was requested earlier this week. I believe we should have that by Monday at the latest. We'll share that.
All right. People would have their witnesses available the 30th.
I believe so, Your Honor.
Preliminary examination in person, July 30th, 2024, 9 a.m. That's before Judge Freshour. Bond continued. Thank you, sir. Court calls case of the People versus Byron Blair.
Andrew Childers appearing on behalf of People.
Assistant Public Defender Natalie Pay on behalf of Blair, who I do not believe is present, Your Honor. Same situation as yesterday, if Your Honor recalls, he was supposed to be in front of Your Honor on a couple misdemeanor matters. However, I had been unsuccessful in getting into contact with him. His phone number is disconnected. He is a resident of the Delana Center, to my understanding. I would respectfully request an adjournment.
Bench warrant, 10,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Court calls case People versus Shanquez Lawson.
Good morning, Your Honor. Ashley Londy for the People.
Good morning.
Good morning, Your Honor. Rita Young, P 44626, appearing on behalf of Mr. Lawson, who I see is joining us in the courtroom. Mr. Lawson, would you state your name for the judge, please?
Shanquez Lawson.
All right, thank you.
Request an
All right, what are we
in-person, oh, I'm sorry, Judge. Request an in-person preliminary examination, please.
And Your Honor, no objection to that. There is ongoing discovery and investigation happening in this case. We're waiting on one more report, which I do not think will be completed until July 26th. So if the court looking at maybe an early August date. And I don't.
Well, counsel, well, when is the discovery going to be in? The 25th?
There's one more report that will not be ready until the 26th.
And I set this for the 30th, so I don't know what.
Judge, that would be, I have 3 other matters that day on the 30th, and I start a jury trial on the 31st. So I have no objection to the first week of August.
We're also still waiting on the final autopsy report, Your Honor.
Or the second week of August.
Preliminary examination will be set in person. Make it August 13th at noon. That's before me.
Thank you, Your Honor.
Your Honor, unfortunately, I start a jury trial on the 13th. I'm so sorry.
Is it going to go all day?
Probably it will be done in one day.
Does he have anything else holding him?
No, Your Honor,
Then
I don't think he does.
this exam's got to go forth. Ms. Young,
He may have a circuit court hold, but I think that
you got anything else holding you?
Then I
Sure.
will see if I can move the jury trial on the 13th to another date, Your Honor.
August 13th, 2024, 9 or 12 noon. That's before me.
Thank you, Your Honor.
And Mr. Lawson, as soon as I get the additional discovery, we will meet again.
Thank you, sir.
Thank you, Your Honor.
Court calls the case, People versus Tyrone Brown.
Yes.
Thank you, Your Honor. Assistant Public Defender Qasim Olvesi on behalf of Tyrone Brown, who is present by Zoom. Mr. Brown, could you go ahead and state your full name for the record, please?
Tyrone Brown.
Thank you.
Thank you. Your Honor, today is the date and time set for PCC. We are in the midst of negotiations for resolution.
I'll be extending the misdemeanor offer for today.
Probable cause conference will be adjourned August 1st, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.
All right, thank you. Thank you, Mr. Brown.
All right, thank you, sir.
Court calls case, People versus Abdul Sumana. I swear. Really? Shocking. Go ahead. All right, we have a French interpreter here. May I have the interpreter?
Do you solemnly swear or affirm that you will interrupt the court accurately, completely, and impartially, using your best skills and judgment, and to translate from English to French and from French into English in the matter now before the court, so help you God?
I do.
Take your name, please, ma'am.
Joanie Messina.
All right.
Equal views on behalf of people.
John Shea. John Shea with it on behalf of Mr. Sumana.
Qui va parler en ton nom.
Okay, what are we doing today?
Qu'est-ce qu'on va faire aujourd'hui?
Your Honor, we have a resolution in this matter.
Votre honneur, on a une
In return for a plea of no contest to disturbing the peace,
l'ordre public
the people will dismiss the two pending felony counts.
va classer donc les deux délits majeurs.
I believe we have tendered to the court a police report for purposes of the factual basis.
Yes.
Le rapport de police pour montrer quels sont les faits factuels.
All right. Sir, can you please raise your right hand?
Monsieur, s'il vous plaît, vous pouvez lever la main droite afin de prêter serment.
Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
La vérité, rien que la vérité, que Dieu t'aide.
Yes.
Yes.
Can you state your name for the record, please?
Pour l'enregistrement, tu peux donner ton nom?
Sumana Abdul Majid. You can put your hand down.
Tu peux baisser. Soumana Abdul Majid, tu peux baisser la main.
Sir, it is this court's understanding that you are going to be pleading no contest to the charge of disturbing the peace.
Sans contestation des droits par rapport au fait d'avoir dérangé l'ordre public.
That is a misdemeanor punishable by up to 90 days in jail and or a $500 fine plus court costs.
Pour aller en prison.
Do you understand that, sir?
Est-ce que tu comprends ça, monsieur?
Oui.
Yes.
Do you understand what a no contest plea is?
Est-ce que tu comprends ce que c'est quand tu rentres une plaidoirie de sans contestation des droits?
Oui.
Yes.
Two things about a no contest plea I have to make sure you understand.
À sans contestation des droits, dont je veux être sûr que tu comprennes.
Is that first of all, it means that you're not further desirous or wanting to contest this charge.
Tu ne vas pas contester les charges contre toi.
The other thing is that for purposes of sentencing, the court would treat you the same as though you had pled guilty.
Ils vont te traiter de la même manière que si tu avais entré une plaidoirie coupable.
I also have to advise you, sir, that while I'm taking your plea,
Que quand je prends ta plaidoirie, monsieur,
I would not be your sentencing judge,
c'est pas moi qui vais être le juge qui va donner ta sentence.
and you would be sentenced before Judge Perry in the 15th District Court.
Et tu vas avoir ta sentence avec le juge Perry au tribunal, le numéro 15.
Is that okay with you?
Est-ce que c'est bon pour toi?
Okay.
OK.
All right. Mr. Shea, the basis for the no contest plea.
Quelles sont les bases?
The potential for civil liability, Your Honor.
Donc, essentiel par rapport donc au civil.
Sir, understanding all of that, to the charge of disturbing the peace, how do you plead?
Pour les charges par avoir troublé l'ordre public, quelle est la plaidoirie que tu veux entrer?
Oh, no contest.
No contest.
You understand that by pleading no contest, you will not have a trial of any kind.
Contestation des droits, tu n'auras pas un procès.
You understand you will not have a trial?
Tu comprends que tu n'auras pas de procès? Yes.
Because of, you understand that, sir?
Tu comprends ça, monsieur?
Oui.
Yes.
All right. Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you,
Certains droits. Tu abandonnes le droit de ne pas avoir de témoins qui vont parler en ton nom,
or to have this court compel their attendance.
ou donc par rapport à son tribunal ici.
You also understand you're giving up your right to see, hear, and question all witnesses against you at trial.
De poser des questions aux témoins qui seront présentés ici durant ce procès.
You're also giving up your right to be a witness for yourself or remain silent
De parler en ton nom ou de demeurer silencieux.
and not have that silence used against you.
Et tu n'auras pas ce silence qui sera utilisé contre toi.
You're also giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt.
Abandonne le droit d'être présumé innocent jusqu'à temps que tu sois coupable dans cette procédure.
You understand you're giving up those rights, sir?
Tu comprends que tu abandonnes ces droits, monsieur?
Oui.
Yes.
All right. You understand you're giving up your right to appeal of right?
Aussi, par rapport à ça, pour faire appel.
Oui.
Yes.
Are you on probation or parole?
Est-ce que tu es donc est-ce que tu es ce qu'on appelle parole ou en période probatoire?
No.
Non.
All right. Has anybody promised you anything other than what's been stated here today on the record?
Quelque chose pour que tu rentres cette plaidoirie. It is my decision.
Has anybody promised you anything other than the felony charges would be dismissed?
Est-ce que quelqu'un t'a promis quelque chose par rapport à ce que ce fait que ce délit majeur soit classé?
Oui.
Yes.
Okay.
One more time.
Encore une fois.
The prosecutor says if you plead no contest,
Si tu plaides sans contestation des droits,
she will dismiss the felony cases.
elle va classer le dossier délit majeur.
Do you understand that?
Tu comprends ça?
Is there anything else that has been promised to you in order for you to plead no contest?
Est-ce qu'il y a quelque chose d'autre qui t'a été promis à toi de manière à ce que tu rentres ta plaidoirie sans contestation des droits?
Has there been any other promise made to you other than the felony charges will be dismissed?
Est-ce qu'il y a d'autres promesses qui t'ont été faites à toi en dehors du fait qu'on t'ait dit que les délits majeurs vont être classés?
No.
Non.
You're doing this voluntarily and of your own free will?
Tu fais ça de manière volontaire et délibérément?
You're pleading no contest because you want to?
Tu plaides sans contestation des droits parce que c'est toi qui veux le faire. Yes.
All right. Mr. Shea, are there any Padilla issues and have they been addressed?
Any
Il y a d'autres points
Padilla.
adressés.
There are Padilla issues.
Donc, il y a eu d'autres problèmes.
We have discussed them.
On en a discuté.
He is in
Il est
ICE proceedings.
dans une procédure avec ICE.
He is a native of Niger.
C'est un natif du Niger.
And he's seeking to remain in the United
Et il
States
veut rester aux États-Unis
with his wife and 2 children.
avec sa femme et ses 2 enfants.
And sir, you do understand that there may be immigration consequences by entry of
Il y
this.
avoir des conséquences par rapport à l'immigration si tu rentres cette plaidoirie? Yes.
And you still wish to proceed with this plea?
Mais tu veux quand même toujours procéder avec cette plaidoirie? Yes.
The court has been provided and has reviewed the University of Michigan Department of Public Safety report
De l'université.
for their case number
Dossier numéro
24
24
249030
30
2842.
42.
Any objection to the court having reviewed that report?
Pour que le tribunal puisse examiner ça?
No objection.
Pas
No
d'objection.
objection, Judge.
Pas d'objection, juge.
Based upon a review of that report, the court does find a sufficient factual basis in which the court could determine the defendant's guilt. Counsel, have I complied with the court rule?
Les avocats, est-ce que j'ai oublié par rapport à ce que vous demandez?
Yes, Your Honor.
Oui,
Yes,
votre
Judge.
honneur. Oui, votre honneur.
The court will accept the defendant's plea
Le tribunal va accepter
of no contest to count 3.
de la comme il rentre une plaidoirie de 100.
Counts 1 and 2 are dismissed.
Le compte numéro 1 et 2, ils sont classés.
Pre-sentence investigation is ordered at 15th District Court probation.
Du 15e probatoire.
I will arrange that.
Je vais arranger ça.
Sentencing in this matter will be
Sera
August 12th,
le 12 août
2024
2024
at 10 a.m.
à 10 heures
before Judge Perry.
devant le juge Perry.
Your Honor, we are not requesting
On ne demande pas
any action with respect to the
une action
bond
par
as of
rapport à la
yet
caution pour
because
l'instant,
there is an
parce
ICE
que
hold
il y a une retenue avec
and we
ICE.
are trying to get that lifted before
On
we have
essaie
his bond
de
reset
l'activer
here.
avant qu'il puisse avoir sa caution ici.
Okay, in that respect, then bond will
Et je
continue.
respecte
Thank
par
you very
rapport
much.
à la caution. Merci beaucoup.
Thank you.
Okay.
Thank you, Madam Interpreter. Pleasure.
Yes, sir.
Do you want to
I did. You already did.
have a good day, everybody?
You do so.
Thank you, Judge.
Court calls the case People versus Simone Sindano.
I'm here, Judge.
Good morning, Your Honor. I'm requesting to practice pursuant to Michigan Court Rule 8.10 under the supervision of Assistant Public Defender Me Rehab.
Who are you?
Oh, I'm Alex Parks. I'm
All right, start again.
Good
Tell me
morning.
your name.
Yeah. Good morning, Your Honor. I'm Alex Parks. I'm requesting to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Me Rehab.
You've not been before me, have you?
I have.
You have?
Once or twice before, yes.
And you forgot to give me your name?
I'm sorry. Yes, Your Honor.
Probably shouldn't let her go then. You forget something that,
One second, the guy that's gonna go.
I didn't even know who she was. She just came up, started talking to me. It's okay. Permission to practice is granted. Go ahead.
Thank you, Your Honor. Ms. Sedano, can you please state your name for the record?
Simone Sedino, and I have a question. I work third shift. So if there
Hold
any
it.
way when I
Say,
have the rest,
hold on. You got to slow down for me. What are you trying to tell me?
I work third shift. So is there any way when you reset my court date, it could be 1 p.m. or after? I still need to be Zoom because I'm Ubering to work. But I've been on Zoom court since 9 this morning after getting off work at 7 this
Okay,
morning.
and I've been here since 8:30. So
You
I
also
can't,
didn't
I
work
got
till 7 in the
50
morning.
Ma'am, I don't think, you know what? Here's what we'll do. I'm going to adjourn this. She needs to appear in person. Zoom is a privilege.
I don't have a way, so that's not gonna happen.
Oh, it better, or I'll come get you.
If I don't have a way, what are you gonna
Probable
do?
cause conference. Probable cause conference is adjourned to August 1st, 2024, 9 a.m. in person. Well, she left. I said what I gotta say.
I'll let her. Thank you.
Okay, and you'll let her know. Those people with the lights show up, that's for her. Court calls the case, People versus Devin Miller.
Good morning, Your Honor. Ashley Lonnie for the people.
Defense counsel something. All right.
And my name is Craig Tank, and I have.
You're breaking up, counsel. Well, now he's froze. Try to send him. Oh, he's kind of back. You turned up. All right, Mr. Tank?
Yes, sir.
All right, we shut your video because I don't think your bandwidth was coming through. Can you state your appearance again?
Yes, my name is Craig Tank, and I appear on behalf of Mr. Devin Miller.
Your name? Oh, go ahead, Miss Lund.
I apologize. I already got my appearance on.
Okay, I thought you did. Sir, what's your name? Devin. Thank you. All right. Yes.
Mr. Miller is Mr. Lawson's co-defendant, and Mr. Lawson was just set for an exam on August 13th at 12 p.m. before your honor, which I don't know if Mr. Tank was able to hear that or not. So the people will defer to what defense counsel wishes. However, it may sort of expedite things to set these both for that date if it pleases the court and defense counsel.
I'm open to what day you'd like me to be there next.
Right, so counsel indicated the co-defendant's preliminary examination has been set. You wish your case set for preliminary examination also, sir?
I would ask your honor that we maintain it for a pre-exam conference if we could, and if you'd like us to come on the 13th, that day is available to me.
I didn't catch that last part.
I think that defense counsel is indicating he would prefer that we stay at the PCC stage.
That's correct.
Okay, so how much time do you want me to adjourn this? I mean, I guess what would be my reason for doing that, number one, and number two, you just need an adjournment of time to continue discussions with the prosecutor? Is that what you're asking, counsel?
Yes, sir.
All right, so here's what I'll do. I'll adjourn the probable cause to August 8th.
Thank you, Your Honor.
2024 at 9 a.m. with the understanding, Mr. Tank, that if there isn't a resolution or something, that if he's going to go to exam, I'm going to put it on the 13th, and counsel for the people would remind me of that.
Thank you, Your Honor.
Yes, thank you very much, Your Honor. I understand.
Thank you. Bond will continue. Thank you, sir. Court calls the case, People versus Yusuf Cyrus.
And Assistant Public Defender Jay Bellinger, on behalf of Mr. Cyrus, who appears next to me, Your Honor. Can you please state your name from the record, Mr. Cyrus?
Yusuf Cyrus. Thank you.
And Your Honor, we have provided a waiver form for Mr.
So you're waiving your right to have a preliminary exam? Yes. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them? Yes. You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution? Yes. People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on counts 1 and 2 with 3 and 4 following.
Thank you, Your Honor. As to that, we acknowledge receipt of the information, waive formal reading and stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as to all 4 counts. Pretrial will be set for
August 27th at 1:30 before Judge Conklin.
August 27, 2024, 1:30.
Thank you, Your Honor.
Thank you. Bond will continue. Yes, she needs to sign that. Court does call the case, People versus Lamar Parker.
Ready, Your Honor.
Your children's hearing on behalf of people, Your Honor.
Good morning, Your Honor. And may it please this honorable court, Allison Fulmer, P 60236, praying on behalf of Mr. Lamar Parker. Please state the name for the record, Mr. Parker.
Lamar Antonio Parker. Thank you, sir.
Your Honor, today's time date set for a probable cause conference in this matter. Your Honor, just on last week, I received approximately 400 pages of paper discovery and about 30 videos.
So you got through it all. Go ahead.
Talk about wishful thinking, all on the heels of coming back from my vacation. I need to obviously go through that, Your Honor. I'm asking respectfully for just a brief adjournment of this PCC to see what I have, speak with the prosecutor's office, and then go from there.
Okay, and how much time do you think you'll need?
Judge, only,
Got the 1st and the 8th and the 3rd, and 1st, 8th, 15th going into August.
first, I'm proud to
Oh,
say I'll be
I
at
don't have
ABA
something.
conference.
I don't have the 15th. I have the 1st, the 8th, and the 13th. Yeah,
We can do the 8th, Your Honor.
All right. No objection from the people.
Oh, Your Honor, thank you.
Probable cause conference, August 8th, 2024, 9 a.m. for a
Thank you
jury
very
invited
much, Your Honor.
bond continued.
Thank you so much, Judge.
The case. You're welcome, sir. Court calls the case, People versus Aaron Daniels.
Your Honor, Matthew Mansour, Assistant Public Defender, on behalf of Mr. Daniels, who appears today via Zoom. Mr. Daniels, can you state your name for the record, please?
Aaron Daniels. Thank you.
Thanks, Your Honor. I'm waiting on additional discovery. If I can request a brief adjournment, please.
Without objection, probable cause conference in these matters will be adjourned to August 1st, 2024, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you, sir. Court calls the case, People versus Tommy Parks III.
Thank you, Your Honor. Assistant Public Defender Constable Dace on behalf of Tommy Parks. My right, Mr. Parks, could you state your full name for the record?
Tommy Parks III, Your Honor.
Thank you.
Yes, Your Honor. At this time, today's date and time set for PCC. At this time, we would be asking for exam.
Discovery is complete.
Yes, as far as I'm concerned.
People would have their witnesses available the 30th.
We'll do our best, Your Honor.
Maybe address bond when appropriate, Your Honor.
Preliminary examination, July 30th, 2024, 9 a.m. That is before Judge Fresh Hour. Yes.
Yes, Your Honor. We would be asking for a PR bond while my client awaits his exam. He does have an alternate place to stay. He is willing to go on a tether if the court deems it appropriate. Reason it being, wants to get back to his family, and he does have seizures, unfortunately, and requires medication for that. He also has a job interview on Monday with Walmart, so we are going at 1:30. So we would just ask for a PR bond in this matter, Your Honor.
Response from the people.
Address that and ask you to revoke the jail calls. You've been calling the victim. It's 18 calls placed, his phone number. We actually talk about the case, talk about a rib still being hurt, about her not coming to court. So I'm concerned that he's not filing bond while he's in bond conditions while he's in jail. Since he's not going to file obviously when he's released. So I'm asking you to revoke the jail calls and remain bond, keep on the same.
Your Honor, my response would be that my client denies that he called the alleged victim in this case. There is another person that he is in a relationship with.
Again?
That's Your Honor, if I may. We're in a polymonogamous relationship.
Okay.
Sure, Jay.
But do they share the same phone?
Yes, Your Honor. And we all live.
Do we have the actual messages? Or
I mean, I have them transcribed, Judge, but I don't have the actual, I mean, I can pull them up and secure it, but I have transcriptions of the messages.
And as I'm understanding what you said, Ms. Blanche, there are specific references to this case.
Correct.
And so, and also as there was a risk that was heard, right?
And Judge, they are speaking in third party. However, there are parts of it based on the conversation where the victim said stuff like, they don't need me at the, then she stops and says, they don't need her at the prelim. So there's switches. I mean, there's deliberate inferences to the case, and there's deliberate, where she switches how she refers to herself in third party.
So at a minimum, it would seem to me if it's the same number and given that, there would be indirect contact with the victim, if even not direct contact.
Your Honor, may I speak?
Yeah.
They do share the same phone. I have my own phone, but it's in property. Every time I do call the number, Your Honor, but I specifically tell Sarah, walk out of the house. I cannot talk to Amanda. We can't pass messages.
When do you say that?
I specifically say it should be in her transcripts.
No, and it says, you doing okay? The victim says, yeah, just still hurt. He says, what? She says, I'm still fucking hurt. He says, you hurt? She says, yeah. He says, where are you hurting? My ribs. Your legs? No, my ribs. Your lips? No, my ribs. Oh, your ribs? Take a couple ibuprofen or something. I mean, and that's where, I mean.
Got it.
Thank you, Judge.
Preliminary examination is set on the 30th. This time I'm not going to revoke his bond. I'm going to leave his bond. So your motion for bond reduction is denied. Defendant's phone privileges are hereby ordered revoked. Thank you.
And that's July 30th, Your Honor, you said?
Yes, July 30th, before Judge Freshour.
Okay.
Thank you.
At what time, Your Honor? I'm sorry.
9.
Thank you.
Thank you, Your Honor.
Thank you, sir. You're gonna want to talk to me at some point. Court calls the case, People versus Vasquez David. At some point, I'm gonna need to talk to somebody. Okay, you're it.
And Assistant Public Defender Lamisa Saab on behalf of Mr. Davis, who is approaching. Mr. Davis, could you please state your full name for the record?
My name is Vasquez Davis.
Okay, you're happy.
Yes, sir.
Okay. Okay. Go ahead. What you doing?
Your Honor, I am requesting an adjournment. I did provide the prosecutor's office some documents last night that I'm hoping will result in a resolution. If we can have a 2-week adjournment, I think that would be sufficient.
Probable cause conference, I'll adjourn this out to the 8th of August, 2024, 9 a.m.
Thank you, Your Honor.
Thank you. Calls the case of the People versus Emmanuel Rhodes.
Assistant Public Defender Lamisa Saab on behalf of Mr. Rhodes. Your name for the record.
And good morning, Your Honor. Sydney Rushing appearing on behalf of Mr. Rhodes as well.
What are we doing?
Your Honor, I'm appearing on the matter that ends in 1738. I know Miss Rushing was just appointed Tuesday, and she needs to have further discussion with Mr. Rhodes. So I would be requesting an adjournment so that depending on what he decides to do on that case, yeah, he wants to follow.
You're in agreement with that, Ms. Rushing?
Yes, Judge, I'm in agreement. We do need an additional PCC date. Hopefully one of your earlier ones versus the August 8th one.
Pardon?
Your Honor, I was just saying, if you have something sooner than the August 8th date that you're giving, just because Mr. Rhodes is in custody.
I don't know why Rushing comes in trying to pick her day. Every time. Every time.
I'm not asking.
Don't even put your hands up like you're not trying to do something.
Judge, I
August
don't
8th,
typically.
2024, 9 a.m.
Your Honor,
No.
You can't do that date?
No, Judge, I was asking if you had anything earlier than that date due to Mr. Rhodes being in custody.
Sure, the 1st. I do this every Thursday.
The 1st is better.
You know that. What?
The 1st would be better if you could give us that date.
She is
If I smile
just
pretty, would that
pushing
be great?
You are really pushing it. rushing. I've let you appear by
Judge-
Zoom and now no, I'm not talking to you anymore. Go ahead, Ms. Saab. What'd you say?
Your Honor, if I can be heard on bond,
Yeah.
whatever date works with Miss Rushing is fine by me.
Oh, really?
First or
We're all
eighth.
deferring to her? August 1st.
Okay, and with regards to bond, Your Honor, Mr. Rhodes would like to respectfully request that the court allow his release with a PR bond and a GPS tether. He understands, we did have a lengthy discussion on his failure to appear back in February. He did explain to me that this was due to his daughter, his oldest daughter, who had collapsed, and at that time he was told that he wouldn't make it. From my understanding, he made a few calls to community corrections to ask for permission to go and see his daughter. Now understanding that that was the incorrect avenue, and that we could have assisted him in getting his bond conditions amended. His daughter did go into septic shock and cardiac arrest. She was in a coma for 4 months at that time. I had discussion with his mother last night, and we're working on getting some proofs for the court. So he would respectfully request that he be allowed to be
Well,
released on.
I'd have to see some verification of what you're telling me.
Okay.
How did he come back into custody after the war?
He was arrested by Ann Arbor in July. He did not turn himself in. And he was at the hospital with his daughter. He failed to appear twice for exam. The first date we gave him grace.
That's true.
We adjourned. The next day, he did not appear again, and there was no notice, there was no contact, there was no explanation, and has never turned himself in. Instead, Ann Arbor had to arrest him just a couple of weeks ago, or last 2 weeks ago.
So motion for bond reduction at this time is denied. All right.
Judge, I take it that means that my bond request would also be denied. So I'm just gonna leave it moot and not even address it at this time.
Oh, I didn't know you wanted to say something else.
No, yeah, Judge, I was.
If you'd
I was
like
letting
to be
my co-counsel
heard.
Speak first. No, Judge.
All right.
All right, I'm not
All
gonna
right.
waste the court's time.
Thank you.
Because I'm not that bad. Come on now. Have a great day, Judge. I'll see you later on today.
Take care. Court calls the case, People versus Mario Delgado.
Andrew Children is on behalf of people.
Assistant Public Defender Natalie Pate on behalf of Mr. Delgado, who should be present via Zoom.
I have two devices, but I have no idea who they are, and they need to start putting their names on.
Your Honor, I did expect him to be here today. We did have a conversation as recently again last night.
I'm
He
here.
was going, oh,
I just don't know how to get my camera to turn on. Can you
What's
hear
your
me?
name?
Mario Delgado. Sorry, I'm,
You don't
creating
know
my
how to
phone
work
screen.
your camera?
No, the app. I don't know how to. Oh, I see. I got you. It's my first time
There you
using Zoom.
go. Okay, I knew you figured it out. We just had to give you time. All right.
thank you, Your Honor. Mr. Delgado will be waiving his right to his preliminary examination.
Is that correct, Mr. Delgado?
Yes.
And you understand that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes.
And you understand that you'll not have that hearing and that you'll proceed to circuit court for further resolution?
Yes.
Preliminary examination, and people also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on all three counts.
Thank you, Your Honor. We acknowledge receipt of the information waived for reading, and my client stands mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
August 22nd, 1:30 before Judge Slade Thursday.
August 22nd, 2004, 1:30, Slade Thursday?
Yeah.
Slade Thursday. Bond will continue. Thank you.
Thank you, Your Honor. Thank you, Mr.
Thank you, Your
Delgado.
Honor.
You can log off now.
And on this one, counsel, so you're aware, I don't have it in brief, so. Court calls case People versus Devin Schiller.
Assistant Public Defender, let me stop on behalf of Mr. Schiller. Would you state your name for the record?
Devin Matthew Schiller.
Thank you.
Your Honor, I am requesting an adjournment. An offer has been made, but it is contingent on a separate case that I will have a response on in the 26th in the 15th district. So depending on what happens there,
So you
we'll
need something
decide what
after the
happens.
26th.
Yes, please.
All right, well, you're coming back with rushing anyway on the first, so I'll adjourn it to August 1st, 2024.
Thank you, Your Honor. And if I may also be heard on bond on this matter.
Sure.
Your Honor, Mr. Schiller is gainfully employed. He works with Johnston and Silvio. He's a handyman there and has been there for the last 8 years. He is working every day on his sobriety and wants to continue working on such. I did have email correspondence with his community corrections agent who indicated that he was scheduled for CCOP, but due to the remand, that's on hold until he is released. He also had an IOP scheduled with Dawn Farm this past Monday, which he missed, but intends on rescheduling. He attends NA meetings on average 4 times a week at Little House, and also has a sponsor who keeps him accountable and honest. He is asking for a PR bond or a low cash bond so that he can continue his employment and working on his sobriety.
The other matter, what is that?
Assault on battery.
15th District Court.
So it's set for a final pretrial on the 26th, which is why.
What's his bond on that one?
It's $10. It was a PR bond, but they put it at $10 just so I got time served.
Yeah, but it will revert if he's released on this case. Judge Valvo's bond will.
How do I know?
PR bond.
Okay, I mean, this is a dangerous situation. I mean, what does he have in place? If I were to let him out and walk out of here today, what does he have in place that's going to keep him? I mean, I've heard you, but that's going to keep him from using. I mean, I have 3 fentanyl tests in a row positive.
That can stay into your system for up to a month. My levels were going down.
Okay. I wasn't here, but I know we had this conversation before. I understand that everything that is going to hold him accountable is not done yet. You know, the IOP with Don Farms, I can reach out and see if I can get him an immediate appointment just to replace the appointment that he missed this past Monday. I can do that between our court sessions today. And then as for the CCOP, I mean, I can't do anything about that unless he is released. That's something that community corrections will assist him with once he's released. If we can keep bond as it is, and I can send something into the court if I do get a response from Don Farm, and then if I can be heard on bond then.
Okay, I don't think I need anything. We will motion for bond reduction to the extent it is at this time denied. Bond will continue as revoked at this point. Thank you. Let's call the case People versus Bruce Dinkins. Can I see that file?
Good morning, Your Honor. I'm Alex Parks on behalf of Mr. Dinkins.
We got that this time. Okay, go ahead.
Your Honor, we were finally able to reach Mr. Dinkins last night, only to find out that he's been in the hospital since Tuesday because of the defibrillator in his chest went off and shocked him. He's having a procedure today. We are able to get the court documentation of his hospital stay. And in this matter, we are requesting an adjournment.
We have the documentation?
We are able to get you the court documentation very quickly. We found out last night from him. It took us a long time to get in contact with.
Okay, I'm trying to figure out what you're trying to tell me.
So we're requesting a short adjournment. There has been a plea offer in this case that our client is ready to accept. And if we could come back in 2 weeks, we would do that then.
Okay, but you don't have the documentation.
We do not have the documentation.
You're going to get it to me.
Yes.
So what you meant to say is you're going to get it to me. You could get it to us quickly.
Yes, we can get the
Okay,
documentation.
that's
quickly.
Thank you. Probable cause conference will be adjourned August 1st, 2024. 9 a.m. bond continued.
Thank you, Your Honor.
And young lady, do me a favor.
Yes.
All right. You come up. You're doing just fine. Just take a deep breath. All right? And just say what you have to say. All right?
Yes, sounds good. Thank you, Your Honor.
Court calls the case, People versus John St. Germain.
Commissioner Contra for the people. Kenneth Overwater, Assistant Public Defender, on behalf of Mr. St. Germain, who stands to my right. Mr. St. Germain, state your name for the record, please.
John St. Germain.
Thank you.
Your Honor, at this time, discovery appears to be complete. I would ask to set the matters for preliminary examination.
People would have their witnesses available on the 30th.
We should.
Preliminary examination in this matter will be in person, July 30th, 2024, 9 a.m. before Judge Fresh Hour.
Thank you, Your Honor.
Bond continued. Thank you.
See that.
Okay, thanks.
Court does call the case, People versus Joseph Taylor.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Taylor, who is approaching. Please state your name for the record, sir.
Joseph Taylor.
Thank you.
Your Honor, my client wishes to set this for a preliminary exam.
All discoveries completed.
To my knowledge, Your Honor, yes.
Yes, sir.
And would the people have their witnesses available by the 30th?
On the 30th,
Yes.
we'll do our best.
All right. Preliminary examination in person will be set July 30th, 2024, 9 a.m. That is before Judge, before me. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Brittany East.
Kenneth Overwater, Assistant Public Defender, on behalf of Ms. East, who should be joining us by Zoom.
Ms. East, you'll need to unmute and turn your camera on. Brittany East. To the next one.
Thank you, Judge.
Court calls the case, People versus Matthew Tipo.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Tiapo, who is approaching. Please state your name for the record, sir.
Matthew Chico.
Thank you, Your Honor. As to the PCC, I am respectfully requesting an adjournment. I did make a referral yesterday to my office's AIM division, so we are hopeful to get some mitigation material together to share with the people. And I would like to also address bond when appropriate.
Okay, but how long is that going to take for, what schedule is your AIM department running on at this point if you just made the referral over?
I would request 3 to 4 weeks, Your Honor.
Probable cause conference in this matter will be adjourned to the 13th at 9. Is that right?
Yes.
Yes, that's the bond.
Thank you, Your Honor. Currently, my client is being held on a $25,000 bond in this case. This is the only thing holding him. At the time of the alleged offense, he was not on parole, probation, or bond. He has no other out-of-county holds. His only prior conviction, according to his Michigan criminal history, is a 2013 misdemeanor conviction. He has no prior felony convictions, and my client informs me he has no out-of-state convictions. We are asking that he be released today on a PR bond. He completely does understand his bond conditions, including returning to court. We are asking that the court lower his bond to a PR and release him today. The allegations in this case are all nonviolent. the charges are crimes against property. We are asking for him to be released today on a PR bond. Thank you.
Response from the people.
I'd ask the bond be continued as currently set. This case, of course, where involves breaking into the water treatment facilities in the township and necessitated a boil water ban for various residents of our county. I'm not exactly sure what the motivation for the crime was, but it's the definition of a community safety issue. And frankly, I don't know whether there's mental health issues at play or what the intent was, but it's a very scary situation that put a lot of our residents in fear.
Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
I'm sorry, Your Honor, what's the adjournment?
The 13th.
Thank you, Your Honor.
Court calls case People versus Devon Ellis.
Your Honor, Peyton DeWitt on behalf of Mr. Ellis. Unfortunately, I got in contact with my client this morning and he let me know due to some unfortunate timing, he was admitted to, or he has a bed at Oakdale. And he chose to check himself into treatment this morning. So we're asking.
Do we have verification of that?
We can get some.
Okay, so he's not here. So what I will do is I'll note the file with what you've said, but at this point, I'm going to issue a bench warrant. 10,000 cash surety. That warrant will issue immediately. If you provide the information, I'll certainly reconsider that, but at this time.
Thank you, Your Honor.
Thank you. Court calls the case of the People versus Jarrell Child.
Good morning, Your Honor. Amy Rice on behalf of the people.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Childs.
Your name, sir?
Jarrell Childs.
Thank you.
Your Honor, I'm going to be asking the court for a competency referral for Mr. Childs. I can provide the report after I get back to the office.
Forensic evaluation is ordered. I'll set a competency hearing October 17th, 2024, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you.
You're down to just custody. Interpreters.
They have next one. Court does call the case of the People versus Kareem Dean. Who's this?
This is fairly, Your Honor.
Hang on. No, don't take him back. You're good. You're good. Court does call the case of People versus Christopher Fairley.
Thank you, Your Honor. Assistant Public Defender Constable Basie on behalf of Christopher Fairley, who is present to my right. Your Honor, can you state your full name for the record, please, Chris?
Christopher Dewan Fairley.
Your Honor, today is the date and time set for a PCC. At this time, there is no offer. So my client is wanting to waive his preliminary exam and seek offer as to the court, Your Honor.
He wishes to waive his preliminary exam. Is that correct, sir?
Yes.
All right. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes.
People also with the right. Limitation having been waived, defendant is bound over to circuit court on all 5 counts.
Your Honor, may we address bond when appropriate?
Well, you're going to have to get the.
I'm sorry.
To do the arraignment.
Oh, I'm sorry. We stand, waive formal readings and stand mute to the charges at this time, Your Honor.
Defendant waive formal reading, standing mute. Court will enter a not guilty. Pre-trial in this matter will be set for July 31st, 2024, 1:30 before Judge Conlon. S.S. to bond.
Yes, Your Honor. My client is requesting a PR bond due to the fact that the allegations in this case happened over a year ago. My client does have 3 children that he needs to take care of at home. He's requesting a PR bond, and if the court deems home confinement or a tether appropriate, then client has no issue with that, Your Honor. He just wants to get back home to his kids.
Any response from the people?
Yes, thank you. Statutorily, the defendant is not entitled to a PR bond at the time of his arrest in this case. At the time of this investigation, because he was arrested later, it appears that he was on federal supervision probation for a federal firearms conviction. The defendant has a substantial criminal history dating back to the late 90s, as far as I can see. In 2006, he was convicted of delivery of crack cocaine in Ohio. In 2010, he was convicted of delivery and manufacture controlled substances here in Washtenaw County. In 2012, he was convicted of a federal firearms offense. In 2014, he was sentenced to federal prison for 7 years, which was to be followed by 3 years of federal supervision. However, in 2020, he violated his federal supervision, and he was then still on federal supervision in April 2023, at the time that he was dealing crack cocaine to confidential informants. The law net was able to do a search warrant of his home, which revealed 11.7 grams of crack cocaine. When the police entered the apartment, the defendant was in his kitchen, actively trying to flush the crack cocaine down his kitchen sink. They also recovered a firearm. They had the opportunity to interview the defendant's roommate. The defendant was essentially sleeping in the living room area and paying rent in the form of cocaine to the person who was legally on the lease. The roommate disclosed to the police that in the days leading up to the search warrant, the defendant had actually committed a felonious assault on him, ordering him out of his own bedroom when the defendant was in possession of a gun. He is facing very substantial charges, and as I said, statutorily is not entitled to a PR bond. And also, I requested 100,000 cash surety when I charged this, and his bond was set at 50,000 cash surety, so he's already been given a verdict.
Your Honor, my response would just be the same, that these allegations were over a year ago, Your Honor. We don't believe he's a further danger to the community at large. And like I said, he's willing to go on any form of home confinement or tether that the court appropriate, as well as any testing that the court would deem appropriate, Your Honor. He really just wants to get home to his.
Motion for bond reduction is denied. Fine, we'll continue.
Thank you.
Yes.
All right, you're all set.
Court calls the case of the people versus Kareem Dean. Okay.
Good morning, Your Honor. Amy Matz on behalf of the people.
Your Honor, Peyton DeWitt, student attorney on behalf of Mr. Dean. Please continue for the record.
Kareem Dean, Kareem Lewis Dean.
Thank you.
At this time, we're requesting a brief adjournment for further negotiation.
First or the eighth?
The first read.
No objection. Hearing no objection. Probable cause will be adjourned August 1st, 2024. 9 a.m. bond continued. Oh. Click decided to show up at the end of the docket. Court calls the case, people versus Ronald Fleming.
That's the money for the people.
Oh, boy. Here we go.
Good morning, Your Honor. Maisie Berger requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Mr. Jay Bellinger, representing my client, Ronald Fleming.
Wow. Impressive.
I memorized it for you.
I know, hey? That's what happens.
I threw away the card.
There you go. You don't need them. Permission to practice is granted.
Thank you, Your Honor. Please state your name for the record.
Ronald Fleming.
Thank you, sir. All right, what are we doing on this case?
Your Honor, we are seeking an adjournment. We have reviewed all the discovery that we have right now with Mr. Fleming, but we discovered this week possibly some new evidence that the prosecution is currently looking into. The prosecution will be out until the 8th, so we are requesting adjournment on the 8th or later.
The prosecution will be out?
Yes.
Your Honor, this morning, Mr. Bellinger informed me of some additional information he's requesting. I need to ask the detective to look into that and see if we can obtain it. There are records that are not currently in the possession of the state at all, or the people. So it's something I have to see if we can get from a private entity.
Got
Yeah, I talked about potential, how long that would take, and I think the 8th is a reasonable turnaround.
All right. Oh, why don't we do this? Let me. Set it on that special on the 13th, give you a few more days. See.
13th, thank you,
Yes.
Your Honor.
2024 at 9, because they're in the morning.
Oh, I see, that's gonna be got it, thank you, Your Honor.
Yeah, so that just take a vacation. All right, thank you.
Thank you.
Thank you. Pardon? Okay. Court does call the case, People versus Tyree Osborne.
Good morning, Your Honor, Amy Riser.
Good morning, Judge Jeanette Hamud here. Mr. Osborne, who's also present by Zoom from the Genesee County Jail. Mr. Osborne, can you state your name after you unmute?
Mr. Osborne, can you, oh, there you go. There you go. State your name, sir.
Terry Osborne.
Thank you. All right.
Judge, today we were scheduled to appear for a PCC hearing. Dr. Went was appointed to as the IME in this case by the MAC office, and Mr. Osborne's not been interviewed. He's scheduled to be interviewed on July 31st. So I'm asking for an adjournment to maybe the second week of August to allow time for Dr. Went to prepare and submit a report.
All right. That objection, I'll adjourn the matter to the 13th. You want the 13th or the 22nd, Miss?
The 13th works, Judge.
Sounds good. Okay. So this is separate competency, isn't it? Yes. So I'll adjourn the competency hearing to August 13th, 2024, 9 a.m.
That's on Tuesday. Is that okay?
Yes, that's a Tuesday.
Okay. Thank you.
All right. Thank you.
Have a good day.
Tuesday.
Yes, it's on a Tuesday. I'm on that date. I have PCCs in the morning, prelim in the afternoon. So.
I'll do it soon. I'll read from the jail.
Okay.
Thank you.
Court calls the case of the People versus Miguel Aparicio Navas. We have a Spanish interpreter. Yes, you may swear her in.
Madam Interpreter, you're in front of the Honorable Bay Senator Simpson out of 14A District, Washington County, State of Michigan. We need your assistance with this matter. Can you please raise your right hand to be sworn? Do you solemnly swear or affirm that you will interpret accurately, completely, and impartially, using your best skill and judgment, and to translate from English into Spanish and from Spanish into English in a manner now before the court to help you out?
Yes, I do.
Thank you.
And good morning, Madam Interpreter.
Good morning, Your Honor.
Court does call the case, People of the State of Michigan versus Miguel Aparicio Navas.
La Corte está llamando en comparecencia al señor Miguel Aparicio Navas, que vamos a llamarle el día de hoy.
If you did not hear that, Madam Interpreter, it was Laura Willingbring on behalf of the people.
Y la señora Lauren Bring, que va a representar a la gente.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Aparicio Navas.
La señora Natalie Page, que va a representar al señor Aparicio Navas.
Okay. What are we doing on this matter?
¿Qué es lo que vamos a hacer para el día de hoy?
Your Honor, my client is waiving his right to a preliminary examination, and he is signing his name to the waiver form now.
Su señoría, mi cliente está renunciando a sus derechos por la examinación preliminar y lo está firmando en este momento.
Sir, is that correct that you are waiving your right to have a preliminary examination hearing?
Señor, ¿es correcto de que usted renuncia a sus derechos para tener una audiencia preliminar?
You understand that's a hearing where the people would be required to show by probable cause that the offense was committed and that you committed it.
Y usted entiende de que eso hubiera sido una audiencia en donde la fiscal hubiera dado las causas probables en este caso.
Sí.
Yes.
You understand you will not have that hearing and you'll proceed to circuit court for further resolution.
Y entiende de que usted no va a tener esa audiencia y que va a proseguir con la corte de circuito para la resolución de este caso.
Sí.
Yes.
The people also waive their right?
Y las personas también renuncian al derecho.
Yes.
Sí, señoría.
Preliminary examination having been waived, defendant is bound over to circuit court on the single count.
Y se renuncia entonces a la examinación preliminar y se va a llevar a resolución de este caso a la corte del circuito. Entonces,
We acknowledge receipt of the information, waive further reading, and my client stands mute. We ask the court enter a not guilty plea.
y estamos de acuerdo con esto y estamos leyendo toda la información y vamos a ingresar una declaratoria de no culpable.
Defendant having waived formal reading, standing mute, the court will enter a not guilty plea.
Y el defendido también entonces renuncia a esta lectura y le estamos aceptando su declaratoria de no culpable.
Pre-trial will be set for July 25th, 2024, 1:30 before Judge Slay.
Y el prejuicio se va a estar realizando el julio 25 a la 1:30 de la tarde y lo va a hacer con el juez Judge Slay.
Bond will continue. Thank you.
Y eso va a continuar. Gracias.
Thank you, Your Honor.
Gracias, su señoría.
Yes. Is that all we need for the Spanish interpreter?
Yes, we just all need one.
Okay, the other
Okay.
person has not shown, so thank you very much, ma'am.
Thank you for using our services. Bye-bye.
All right, have a great day.
You too.
I think now we have an Arabic interpreter.
Yeah.
Yes,
Good
sir. This
afternoon,
is-
Sonia. You're in front of the Honorable State Senator Simpson out of District Court, Washington County, State of Michigan. Our number is 1423.
Thank you. And thank you for using our service. Go ahead.
Thank you. Can you please turn on your camera and raise your right hand to be sworn?
Sure.
Thank you. Do you solemnly swear or affirm that you will interpret accurately, completely, and impartially using your best?
I'm sorry, ma'am. I can't hear you. You're fading away.
Do you solemnly swear or affirm that you'll interpret accurately, completely, and impartially using your best skill and judgment, and to translate from English into Arabic and from Arabic into English in the manner now before the court, so help you God?
Yes, ma'am.
Thank you.
All right. And good morning, Madam Interpreter.
Good morning, sir.
Court does call the case of the people of the state of Michigan versus Omar, is it Alahari?
That's correct, Your Honor. This is Matthew.
نعم
I'm sorry.
المحكمة بتنادي القضية تاعت الشعب تاع ولاية ميشيغان ضد السيد عمر الأوهاري. Sir, before we start, can I make sure that he can understand me?
نعم
Yes.
نعم أنا فاهم معلش.
عم تفهم علي?
نعم.
Okay, go ahead.
All right.
We can
Nimish
continue.
Ganatra for the people.
وهون أطرف بالنيابة عن الشعب.
And Matthew Mansour, Assistant Public Defender, with and on behalf of Mr. Alahari.
وماثيو منصور محامي الدفاع العام بالنيابة عن السيد المهاري.
And your name, sir?
وأستاذ اسمك؟
عمر العاهري.
عمر العاهري.
The court has before it a plea form that indicates the defendant will be pleading guilty to the charge of use of a controlled substance.
المحكمة في أمامها نموذج الإقرار بأنه المدعى عليه راح يقر بالذنب بخصوص استخدام مادة ممنوعة.
نعم.
Yes.
And on a successful plea to that charge, count one would be dismissed.
وبناء على نجاحه بالإقرار بالذنب لهي التهمة فقرة التهمة الأولى رح يتم إلغائها.
تمام.
Okay.
And there's also no objection to 7411 if he's otherwise eligible.
وكمان ما في عنا أي معارضة بالنسبة ل 74-11 إذا كان هو مؤهل لهذا الشيء.
تمام.
And that is the court's full understanding of the agreement. Is that correct, counsel?
وهذا كامل فهم المحكمة بالنسبة للاتفاقية. هل المحامي موافق؟
Yes, it is, Your Honor.
نعم حضرة القاضي.
Sir, can you please raise your right hand to be sworn?
أستاذ هل ممكن إنه ترفع إيدك اليمين حتى يتم أخذ منك الحلفان؟
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
نعم هل أنت بتقسم وبتأكد إنه كل المعلومات اللي رح تعطينا إياها ما رح تكون إلا الحقيقة كامل الحقيقة ولا شيء غير الحقيقة الله يساعدك على هذا الشيء.
نعم.
Yes.
All right. Can you state your name again for the record?
هل ممكن تذكر اسمك مرة تانية للسجل؟
عمر العاهري.
Sir, it is this court's understanding that you're going to plead guilty to the charge of use of a controlled substance. That is a
فهم المحكمة إنه أنت راح تذكر بالذنب بالنسبة لاستخدام مادة ممنوعة.
نعم.
Yes.
That is a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs.
نعم هاي تعتبر جنحة I'm sorry, Your Honor, can you please repeat? I lost my thoughts.
Yes. It's punishable by up to 1 year incarceration and a $1,000 fine plus court cost.
نعم هاي تعتبر جنحة وبالتالي العقاب لإلها رح يكون سنة سجن بالإضافة إلى $1,000 غرامة مالية بالإضافة إلى تكاليف المحكمة.
You also need to understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
نعم وكمان لازم انه انت تفهم انه انا خلال اخذي الاقرار بالذنب منك انا ما رح اكون القاضي اللي رح يحكم عليك. القاضي اللي رح يحكم عليك رح يكون القاضي واشنطن بغرفة المحكمة 14 ب من مقاطعة المحكمة.
Do you understand all of that, sir?
نعم.
هل أنت فاهم كل هاي الأمور أستاذ؟
نعم.
Yes.
And so to the charge of use of a controlled substance, how do you plead?
وبالتالي بالنسبة للتهمة باستخدام مادة ممنوعة شو ردك على هاي التهمة؟
مذنب.
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
أنت فاهم إنه عن طريق الإقرار بالذنب ما رح يكون لك محاكمة من أي نوع.
نعم.
Yes.
You signed an advice of rights form today, is that correct?
وأنت وقعت ورقة بتنصحك بالحقوق تاعتك اليوم صحيح؟
نعم.
Yes.
Do you have any questions regarding any of the rights on that form?
هل في عندك أي سؤال بالنسبة لأي من الحقوق المذكورة على النموذج اللي وقعته؟
لا.
No.
You understand that you're giving up all the rights contained on that form?
وأنت عم تفهم إنه أنت عم تتخلى عن كل الحقوق المذكورة بهذا النموذج.
نعم.
Yes.
You understand that you're giving up your right to appeal of right?
نعم كمان أنت عمالك بتفهم إنه أنت عم تتخلى عن حقك استئناف حق هذا الحق.
نعم.
Yes.
Are you on probation or parole?
هل أنت حاليا بفترة تجربة؟
نعم. Yes. No. No.
Let me try it again, Madam Interpreter.
Sure.
Are you on probation or parole, sir?
هل أنت حاليا معفى عليك تحت التجربة؟
لا.
No.
Has anybody promised you anything other than what's been said here today on the record to get you to plead guilty?
هل في حدا وعدك بأي شيء غير الأشياء المذكورة بالسجل حتى يخلوك تقر بالذنب؟
لا.
No.
You're doing this voluntarily and of your own free will and because you believe that you're guilty?
هل أنت عم تعمل كل هاي الأمور طوعا وبإرادتك الحرة ولأنه أنت بتعرف إنك مذنب؟
نعم.
Yes.
On March 30th, 2024, at I-94 in Ypsilanti Township, I'm sorry, man.
نعم بتاريخ 30/3/2024 على طريق I-94 بإبسلاني تاونشيب.
Did you have cocaine in your possession?
هل كان بحوزتك كوكايين؟
No.
No. Did you have a controlled substance named, is it cathinone? in your
هل-
possession?
هل كان في حوزتك مادة ممنوعة اسمها كاثانون اسمها بحوزتك؟
نعم.
Yes.
Had you used that drug, sir?
هل استخدمت هذا المخدر أستاذ؟
نعم.
Yes.
All right. And you knew what you were using was that drug cathinone?
نعم، وأنت كنت عارف إنه هذا المخدر اللي أنت كنت عم تستخدمه اسمه كاثانون.
نعم.
Yes.
And did you have any authority by way of a lawful prescription or any other authority to use that drug?
وهل كان في عندك صلاحية من خلال روشتة إنك أو أي شيء تاني بيعطيك الصلاحية إنك تستخدم هذا الدواء؟
لا.
No.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes.
Yes.
Go ahead, Madam Interpreter.
I'm sorry, Your Honor, I didn't hear you.
Okay. I asked counsel, have I complied with the court rule and would it be proper to accept this defendant's plea?
نعم أنا بسأل المحامي إذا أنا اتبعت تعليمات المحكمة أو قوانين المحكمة وهل رح يكون مناسب إني أقبل إقراره بالذنب. الجواب كان نعم.
Yes, Your Honor.
Yes, Your Honor.
نعم حضرتك نعم.
The court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed.
نعم المحكمة رح تقبل إقرار الذنب للتهمة 2. التهمة فقرة 1 رح يتم إلغائها.
A pre-sentence investigation and report and screening assessment is ordered at 14B District Court.
نعم فحص ما قبل الحكم وتقرير وفحص رح يتم تسجيله بالمحكمة 14B.
Sentencing will be August 29th, 2024 at 10 a.m.
الحكم رح يكون بتاريخ 29/8/2024 الساعة 10 صباحا.
Bond will continue. Thank you.
وسند الكفالة رح يستمر فيه. شكرا.
Thank you, Madam Interpreter. Do appreciate it. Wonderful job.
Thank you, sir, for using our services. Bye-bye.
Okay, bye-bye. Court does call the case of the people versus Escorcia. Is it Alvarez?
Assistant Public Defender Hannah Apple appearing on behalf of the defendant. Your Honor, I was informed by the jail staff that Mr. Alvarez was released to Immigration Customs on Tuesday.
Ah.
So he is not here.
So INS has him, or ICE has him.
Yes.
Okay. Well, what I will do is I'll issue a bench warrant for failure to appear, understanding that. On 10,000 cash.
Thank you.